Miss Wendy, yes, can you come back and get my from staff? Oh, so
Sure.
she can take off.
Yep, I'm in the office.
Thank you so much.
All right, and
Check this bag as well.
okay. Mr. Brodowitz, how are you?
Good, how are you, Aaron?
Pretty good. What case do you anticipate next?
I mean, we can go on.
Once Mrs. Holden gets back and
We can go on, I think Jackson is probably ready. Washburn, I know with Mr. Abbott, I think is a good go. I know we have to bring her up.
all right,
Um,
and then Mr. Moss is here on Mrs. Strowski, and
yeah,
we should address that
So
also.
that one, I don't know if you want, because I expect Jackson. I haven't seen, I'll just give you a
Okay.
preview.
All right,
I haven't seen, or if I can approach it quickly.
you may. Mr. Goodrich, you have Mr. Jackson?
Yes.
You can,
Yeah.
you certainly can approach.
So, yeah, I haven't seen it, but-
We're on the record in docket 22-02853. That's people of the state of Michigan versus Dominique Jackson. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Jackson, who's standing to my right.
And sir, you are Dominique Jackson?
Sir.
All right, this is the time set for a preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for preliminary examination. The people have subpoenaed witnesses. However, to my knowledge, those witnesses have not appeared. I've called the hallway in the courtroom. I would like to put it on the record that the complaining victim in this matter, Ms. Trevino, did contact the prosecutor's office once to say that she was pregnant and had just had an operation and was on bed rest. However, I have been unable to get in contact with her to confirm that in any way. So at this time, I would leave it to the defense.
All right, Mr. Goodrich, your position today.
Your Honor, we would ask the court to dismiss this matter as we are ready to proceed with the exam. I would point out that this case is 8 months old at this point, so a phone call regarding a woman being pregnant, that could be a long time ago. So I don't know what the story with the witnesses are, so we would just ask the court to dismiss the matter.
All right, with that understanding, the people are unable to proceed today with the preliminary examination. There's been some contact with the complaining victim, but it was not able to be confirmed or followed up on. So the court would entertain the defendant's motion to dismiss and granted. It's dismissed without prejudice. the translation for that, Mr. Jackson, is the people could reissue if they choose to reissue, but for our purposes today, the case is dismissed. All right, sir?
Yes.
All right. Anything else for the record in docket 2202-853, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Goodrich?
No, Your Honor, thank you.
All right, for the record, I'm signing on the motion to dismiss without prejudice. You're all set.
Thank you, sir.
Thank you, sir.
I'm gonna go look for my other client. Okay, just have a seat back here if you like. You'll-
Oh, he's looking for Mr. Thomas. And then we'll decide what to do on Mrs. Strauss.
I can go, I saw Mr. Abbott out in the hall. Well, we gotta bring.
If
up
he
Mr.
wants to, we can put that on the record. I don't know if Miss Washburn's here or not.
I believe she's downstairs.
All right. I have a Samsung person.
That,
Find out who it is. Good morning, Ms. Housefield.
Well, I'm going to chat with you in another.
Oh.
session. Hi, ma'am.
okay. I don't know if it's good or bad. I think I have a minute.
No.
You have a minute.
Yeah.
Yeah, we're just waiting.
Okay.
Yeah, we're.
That's people of the state of Michigan versus Alfred Thomas. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Thomas, who's standing to my right today.
Sir, you are Alfred Thomas? All right, this is the time set for preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for preliminary examination. After conversations with the defense, I believe that there is going to be an unconditional waiver of the preliminary exam. So at this time, the people would move that the case be bound over to circuit court as charged.
And Mr. Goodrich, with that's your understanding?
Yes, it is, Your Honor.
Okay. And negotiations are to continue in circuit court.
That is correct.
May I inquire of Mr. Thomas of his waiver?
Yes, Your Honor.
All right, thank you. Mr. Thomas, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. You understand that, sir? A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that? You, of course, are represented by Attorney Public Defender Mr. Goodrich, and he would be here to contest any charges and cross-examine any witnesses brought against you. Do you understand that? Okay. With that understanding, it's my understanding that you intend to waive your right to a preliminary examination and move this case on to circuit court, which is the trial court in this matter. Is that correct?
Yes, sir.
All right. So you're with your waiver to your right to preliminary examination, Mr. Brodowitz, do the people waive their right to preliminary examination?
Yes, Your Honor.
Okay. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I will yield. So please keep in contact with your attorney, Mr. Goodrich. Any future date will not be in district court. It'll be in circuit court over the Grady Porter building. And that's where this case will move on. This case is bound over as charged. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 23-01460, Mr. Brodowitz?
Nothing from the people, Your Honor.
Mr. Goodrich?
No, Your Honor. Thank you.
All right. I'm gonna have to sign the waiver of examination. And then I don't see a signature. Oh, there is on to the consent waiver, there's a prosecutor's. And then I'll sign that order. Mr. Abbott, how are you?
Well, Your Honor. You?
Good, good.
I already knew she was downstairs.
For the record, I'm signing the waiver and you're all set.
All right, thank you, Your Honor.
Thank you.
I'll call you 2 weeks after I get everything. Okay.
Nice sign that.
Yeah, well, that's why I'm trying.
Yeah.
And Mr. Milks is back there.
I don't know. I hope so.
How about?
I mean, we can bring up this Washburn.
And is that for Mr. Abbott?
Yes.
All right, and she's incarcerated?
I believe she's downstairs.
Okay. Mr. Washburn, and we'll put that adjournment on the record. Okay.
I didn't see.
Would the individual on the Samsung please identify themselves? would the person on the Samsung SMS918 please identify yourself? Would the person identified as Mimi please identify yourself? The person with identifying themselves as Mimi, please identify yourself.
Yes, that's what.
So Ms. Smith, you're ready to go on yours.
Yes, sir.
All right, well, let's see what we can move in front of it since we've got,
That's, I'm trying to move everything else.
yeah,
as fast
just
as
we can
possible.
move, since we're gonna take some time up. And we have, I know that we have one that's Mr. Moss is here on that we have to deal with.
Yeah.
Mr. Stevens, are you all set today?
I was looking for Wendy.
She's,
I'm sure she's hiding from me.
She's often never
there she is right there.
Yeah, she doesn't want to see my face.
Hi, Andrew.
You have to go fast.
So she'll send it.
How many witnesses do you anticipate, Ms. Smith?
Just one, Your Honor.
All right.
They'll send it. It's a commitment.
Oh,
Yeah,
all right.
it's
I'll tell
literally,
them to look out for it in that then.
yeah, it's literally in the commitment paperwork
Done.
that they get. It'll be, you know how on a 53 or pretrial release, it's in that U at the very bottom. They'll say phone conversations or.
So, Mr.
But yeah, we
Lucky,
don't do a separate word.
I
It's
have
just
not.
included in the bond conditions now.
I know he appeared by Zoom for the pieces.
I don't believe they probably processed
All right.
that.
I can
yet.
go out.
No,
and see it
I-
in the hallway at
let's
this point,
see.
Your Honor.
let's see if I'll readmit these and they don't answer me. They're going back in the waiting room.
Right. And then you double. And so I'll just tell them.
Yeah. Isn't it?
They said, "Well, if we're gonna come through that,
Sarah Johnson, would you identify yourself and what case you're here on?
then Ralph."
You're welcome. Yeah, anytime that you change.
Sarah Johnson, will you identify yourself and what case you're here on?
Your Honor,
Yes.
Mr. Lucky's out in the hall.
Okay. Let's put her back in the waiting room. With the individual on the Samsung, please identify yourself. This is being streamed live on YouTube, so you're welcome to come to that channel. But without identification, I'm going to remove you from the courtroom. So Mr. Lucky is here.
Yes, he's outside.
Let's go ahead and bring him in. He doesn't have counsel today, does he?
I don't believe so.
All right.
We have not gotten an appearance. I did check this morning.
I don't think he was.
I'm just looking at the examiners probable cause. We should get an attorney to see this denied hearing.
Yeah.
Yes. I think I wrote in the file, is there a couple things about that? Or something?
Told to get attorney and appear for preliminary and set above.
Yeah, I write something about judgment.
No, that was, yeah.
Okay. I've been trying to take better notes.
All right, so we're on the record in docket 23-01394. That's people of the state of Michigan versus Carlos Lucky. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Sir, you are Carlos Lucky?
Yes, sir.
All right. This time set for preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for preliminary examination. However, I believe Mr. Lucky is unrepresented at this point. And I would ask, I guess, for an adjournment so that Mr. Lucky can obtain counsel due to the charges in this matter.
All right. For the record, this is a 10-year and a 93-day. It appears that Mr. Lucky was denied court-appointed attorney on May 17th, 2023. On May 19th, Judge DeLuca, who was covering on that day, indicated that the defendant appeared, he told him that court-appointed attorney was denied. Defendant was told to get an attorney and appear for preliminary examination on set above. So on May 26th, you're here, and once again, you do not have a lawyer?
Well, Your Honor, I had the intention of getting a public defender, and
You already know that you've been denied a public defender.
correct. And I tried to get counsel, and everybody wanted a $5,000 retainer, which I can't afford.
All right. And so did you want to reapply to the court appointed to the public defender's office? Because you've been denied one time. It's either that or go forward on your own. And this is a 10-year felony. So that would be in my opinion, that would be a really bad idea. But what I can't do is keep adjourning this because you don't have a lawyer. So did you want to make, so you're indicating that you can't afford $5,000 a retainer or whatever you've been quoted. And so your only other option is to go back to the public defender's office and reapply. Is that correct? And you've already applied and been denied. Is that correct?
Yes.
All right. So what I'm going to do is I'm going to find good cause to adjourn this. I'm assuming you're requesting an adjournment. You don't want to go forward today without a lawyer.
No.
Okay, that would be a stressful idea to go through the hearing.
I understand.
It's so, and it probably would put your rights at issue here, as far as I'm concerned, since this is a 10-year felony and you want a lawyer to look at the case and to zealously advocate for you, correct?
Right.
All right. For the record, Officer Neves has given you contact information for the public defender's office. Is that right?
That's correct.
All right. And so what I'm going to do is adjourn this out for good cause. You don't have to waive any right. I don't think that's appropriate. I think we're going to adjourn it out for good cause. Okay. So this is a good cause adjournment. I'm assuming it's at your request to get you so that you can get a lawyer.
Yes, sir.
I will tell you what's going to happen next time to both parties, Mr. Brodowitz and Mr. Lucky. So if you come back here without a lawyer, we're just going to go to prelim, okay? You'll be bound over without attorney because I can't prolong the case and you've been denied attorney. I'm going to expect that this has the highest priority for you right now. You're going to go right over and make application and get a lawyer so your lawyer has time to look at this and to figure out your best representation. But if that doesn't happen and we come back here and you don't have a lawyer, we're just going to go forward. Okay.
Okay.
All right. Do you understand that, Mr. Brodowitz?
Yes, sir.
So all witnesses here for the next date. We'll set it pretty timely, but enough time for any attorney you have to look at the case. So D to go to public defenders. And I will indicate this is 3,000 PR bond on a 10-year. You should have an attorney look at this, all right? Because what I could do is remand you until the prelim and have you make application and just have it from jail. You've had no fail to appears, so I'm not going to do that, okay? But you need that's how serious a matter this is. So you really need a lawyer to look at this for you, okay?
Okay.
Is that a yes?
Yes.
All right. Date?
June 9th at 9.
So we'll set this for June 9th at 9 a.m. We'll see you live in person on June 9th at 9 a.m. With counsel. All right, sir?
Okay.
All right. Thank you. That's all set. We're all set for the record 2301394. Anything else, Mr. Brodowitz?
Nothing from the.
All right. Thank you. Have you had the opportunity to speak with your client?
Yes.
Ms. Washburn,
Yes.
and you ready to go, Mr. Abbott?
Yes.
Mr. Nichols, you're here on Ostrowski. I saw Mr. Moss earlier.
Yes, I
All
am.
right.
Good morning.
So we should be ready to go on that one. We'll put anything on the record on that case. All right, so we're on the record in docket 22-03252. That's people of the state of Michigan versus Brittany Washburn. Will the parties please introduce themselves for the record?
Jeff Radowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Brittany Washburn. She is standing to my right.
And ma'am, you are Brittany Washburn? All right, this is the time set for preliminary examination. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After conversations with the defense, I believe that the parties have agreed to adjourn this matter, and that Ms. Washburn will be waiving her 21 days. That is, I put on the record because the complaining victim in this matter had a pre-planned, prepaid for family vacation that made her unavailable, but also, as I learned, I guess last night and into this morning, I don't believe Mr. Abbott has yet received discovery from the prosecutor's office. So for those reasons, I believe the parties have agreed to adjourn this matter.
Mr. Abbott.
That's correct, Your Honor. We understand his witness is not available, and I have, as of now, still not received discovery, although I know people are working on that. Our appearance was filed on the 10th, so I'm not sure, I don't know what happened.
All right.
I hope the court will find that that's good cause and she won't have to wait, but we will if it's necessary.
Let's see, the appearance was filed on May 10th. This is May 20, that's 2 weeks ago. It's almost 2 weeks ago. Let's see, 10th, 2 weeks ago. And you still don't have discovery. I don't think, I think you should have discovery before your client decides to waive the right to a preliminary examination, a 21-day rule. So I'm gonna find that there is good cause. Since your appearance was filed, there is good cause to adjourn based on your motion and appearance filed on May 10th. So you understand, Ms. Washburn, you don't have to waive any rights today. You still have your right to a prelim. You still have to have your right to a prelim within a timely manner. I have found good cause to adjourn because it's been 2 weeks and your counsel should receive discovery on the case and he is not. All right. So when we come back here, counsel will get discovery. He'll have the opportunity to talk, but you've not waived any rights in regards to the timeline or your preliminary examination. Do you understand that, ma'am?
Yes.
All right. So new prelim date set for?
June 9th
June 9th
at 9:30.
at 9:30. And then if there's any problems with the discovery, Mr. Abbott, as we get close to that date, just let the court know, okay?
I
All
think
right.
it's being worked out. I know there's people in our office that are working on it.
All right.
I have a note in our system that it was emailed and shared yesterday. Why the delay? I can't.
All right.
But
All right. As long as we get it there for June 9th and we get some review of it. All right. Anything else for the record? Docket 22-03252. Mr. Brodowitz.
nothing from the people. Your
Mr.
Honor.
Abbott.
Not from the defense.
All right, Ms. Washburn. We'll see you here on June 9th. Okay, ma'am? All right, Miss.
I think you want to do that one. I think we might be ready to go on Kinley as well.
You tell me, I don't see Mr. Milks here. Oh, here he is. Right. Let's do that case first, and then we can address the several files for Mrs. Straussky. when you're ready, Mr. Milks, on Mr. Kinley.
Yes, sir.
All right.
But this was time, and then if it goes up to circuit court, it goes to the circuit court, it would be flagged in district court, and then kill it. Right. If you flag the district, yeah. Oh, correct. I'll be fine. Yeah, I'll just
Right.
put that on.
Yeah.
All right, so we're on the record in docket 23-00901. That is People of the State of Michigan versus Desmond L. Kinley. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Kinley, who is present and standing to my right at this time.
And sir, you are Desmond Kinley?
Yes, sir.
All right, this is the time set for preliminary examination today. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After conversations with the defense, it is my understanding that the parties have agreed to unconditionally waive the right to have a preliminary examination here today. And so the people would ask that this charge be bound over to circuit court as charged in the complaint. And with that, I would just like to add for the record that an offer has been extended of pleading to an added count 2. Let me just, sorry. Of possession of cocaine, heroin, or other narcotic less than 25 grams. And that offer remains open up to circuit court with negotiations to continue in circuit court.
And that's your understanding, Mr. Milks?
Yes, Your Honor, that is a complete and accurate statement.
May I inquire of your client of his waiver?
Yes, sir. Thank you.
All right, Mr. Kinley, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment?
Yes, sir.
All right, it looks to me like you waived that 21-day rule.
Yes.
So and you also have a right to preliminary examination as a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You understand that, sir? You, of course, are represented by a public defender, Mr. Milks, and he would be present to cross-examine any witnesses and contest any charges brought against you. Do you understand that?
Sir.
Other than what the attorneys have indicated, that this is an unconditional waiver with negotiations to continue, and there is an open offer of possession of cocaine. Has anything else been promised to you concerning your waiver?
No, sir.
All right. Is it your intent today to waive your right to a preliminary examination and have this case continue on to circuit court,
Yes.
the actual trial court?
Yes, sir.
Okay, I find that the waiver of the preliminary examination be knowing, understandingly, and voluntarily made. Mr. Brodowitz, you also waive your right to a preliminary examination, people?
Yes, Your Honor.
All right. With that understanding, I'm going to have to sign the advice of the examination waiver. Please keep in contact with your attorney, Mr. Milks. Your next date will be in circuit court. And so that's the next date. Your time here in district court is done, and your next date in circuit court, which is the trial court. All right, sir?
Yes, sir.
All right. Sign. Mr. Milks, if you could sign the examination waiver, and I think there's a place for the prosecuting attorney also.
Thank you, sir.
You're welcome. Thank you, Mr. Mills. All right, Mr. Kinley, you're all set. Thank you for your appearance.
All right, thank you, sir.
Would the individual on the Samsung please identify themselves once again? The person on the Samsung SMS9, would you please identify yourself? I don't know what that means, but,
Connected audio, Judge, they can't hear you.
oh, okay. Who's Gerald Eves?
Mr. Eves is a witness for us for the preliminary examination.
All right. He was planning to attend by Zoom?
Yes, Your Honor. He, due to the short notice, he was unable to get the time off of work.
Well, he certainly can be, he's not connected audio either.
Co-host, please. Make it co-host.
Sure. I've just been moving people out when they don't identify themselves. I've been,
Booting everybody out of
I have
today.
been. So
It's
I
a
will
new
make you.
system.
My system is that I don't hear from you. You have to leave the room. And Samsung's, you're right. I've booted him a couple of times. Of course, I didn't look to see that he couldn't hear anything. I guess it doesn't matter. We're also streaming on YouTube, so
I have some exhibits to mark if I can. bring them to you.
I would wait on that
Oh, wait,
until,
okay.
yeah, until we figure out what Mr. Brodowitz is doing today. All right, so let's start with the preliminary examination that was scheduled for today. So let's start with, and then I would give anybody time to mark anything if this falls through in any way, or because we have a couple matters to deal with, but it just makes sense. But based on representations that the prosecutor made already, there's some question whether we're going to go forward with the prelim today.
I see.
Okay, so and since you haven't had the opportunity to speak to Mr. Brodowitz, let's just put it on the record.
Okay.
All right. So we're on the record in docket 23-01396. That's people of the state of Michigan versus Valerie Ostrowski. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
May it please the court, Michael Nichols on behalf and with Ms. Ostrowski. Co-counsel Jackie Moss is also in the courtroom.
All right, ma'am, you are Valerie Ostrowski?
Yes.
All right, thank you. This is the time set for preliminary examination today. I've had some brief, just trying to figure out where the docket is because we have a prelim going this morning on another case. I inquired of Mr. Brodowitz of what he anticipated when this was going and how to look at this, and he indicated that there may be something done by the prosecutor's office in relation to this file. So I just thought, let's put it all on the record.
Very well.
Yeah. So Mr. Brodowitz, how are we proceeding today on docket 23-01396?
Yes, Your Honor. At this time, the people would seek to add a second count. I should say count two, which would be to misdemeanor breaking and entering illegal entry without owner's permission. And that's under MCL 750.115A, which is a 90-day misdemeanor or $500. And the people would seek to dismiss count one in this matter.
All right. So my understanding is then that you'll be amending the felony 2.5-year under $1,000 attempted home invasion to a 90-day misdemeanor, the unlawful entry. Is that correct?
Illegal entry without owner's permission, Your Honor.
Legal entry without owner's permission. And that's under 750.115 parent A, and you're requesting a dismissal of the original count, felony count one.
Yes, Your Honor.
Mr. Nichols.
Well, Your Honor, as the court knows, they make the call on what to charge and how to charge it.
Right. So I'm assuming that there's no objection to the court changing this to a misdemeanor under a 90-day misdemeanor as opposed to the 2.5-year felony.
Fair assumption, Your Honor.
Right, okay. So the court at this time will dismiss the original felony count of count 1 for preliminary examination purposes. There's no need for preliminary examination because the case has been reduced to a 90-day misdemeanor. And I would only think that it would be appropriate at this time to set it for pretrial on the misdemeanor, unless you want a jury trial date at this time. A pretrial date seems to be.
Makes sense.
Yeah, so since we have a brand new charge. So set for pretrial date on. And we didn't anticipate this, so we're looking for a date.
Fair.
Just a regular pretrial?
Just a regular pretrial date.
Six at 10:30?
June 6th to 10th. How does that work with your schedule, Mr. Nichols?
It's not good for me, but Mr. Moss will probably handle it anyway.
I've got a plea hearing at that time, Your Honor.
All right.
What time is your plea?
That is at, actually, that case is in this building actually at 10 o'clock, Your Honor.
Okay, so we can make it at 10 and then you can let us know. Let us know where you are. We'll be fighting for you.
It'll
Okay.
be at 10:30 for us.
Okay, so it'll be 10:30 for us, but just keep in contact with Wendy and Wendy Holden and Mr. Brodowitz, and we'll set you in for that pre-trial. So that's all for the record and docket for the prelim of docket 23-01396. And as I looked at the underlying, so we have a sentencing that we'll address, and we have a bond hearing. And I've looked at the court rule, which is always a dangerous thing to do, is to look at the court rule. And for the bond violation, and the bond violation, if there's an indication that, but I want to make sure that this is all set on that we've had this on, that we're all on the record on this. So we are currently, so this is for the docket 23-00011. This was set for sentencing today, and it was also set for a bond violation, a scheduled bond violation in regards to the case that was just indicated, which was a violation of bond for coming in with the no contact in regards to the residence that's at issue here concerning this case. The brief what I've looked at, been able to look at what's been submitted, that is at issue, as whether there was a pretrial order or a court order out there, a pretrial order and the intent concerning that. So it's my understanding, and that's part of this issue, is the violation of the law and within 1,500 feet, the violation of the pretrial, which is the bond violation, which is essentially the pretrial order. And as I looked at this, I saw there's an indication that for a non-technical violation, the court does not have to have a written bond violation. It says may. Okay, the rule says may, and I'll cite that for the record.
You on MCR 6106?
I am.
Okay.
I am on MCR.
H or I. If you're looking for I2, if the defendant has failed to comply with the conditions, etc.
Yeah, I just wanted to make sure that we did this, that court may issue a bench warrant or summons. So it's 6.445A. the court may issue a bench warrant or summons upon finding probable cause to believe that a probation has committed a non-technical violation of probation. I'd prefer to treat this so arraign her on this. So we treat it as, so she has some notice of this, because I could not find a bond violation in the file concerning the no contact, and one was never, I don't need one, but it seems to me that that would be the more appropriate way to go, is to indicate the nature of the bond violation, give her notice of what she's facing, what your client is facing, so that we can set it for hearing. Because the sentencing, and I'm telling you my thought process, this is the sentencing and the misdemeanor complaint. I received a volume of information concerning that yesterday at 4:07 is when we marked it. So in order for me to read it and digest it, and there's case law associated with it, and it all goes somewhat to the heart of the issue of whether there was a valid pretrial release order in the file, or maybe a jury should figure that out. But I'd like time to look at it in regards to sentencing, because this is set for sentencing today at 9 today, and I got it pretty late last night. So it would appear to me that the one way to treat this, and I'll let counsel take any comment from counsel, is to make sure that Ms. Ostrowski understands the nature of the probation violation, because I don't think that's been put in writing. It doesn't have to be, but this is kind of a belt and suspenders approach to making sure that she has notice of this.
And I want to make sure are we talking probation or bond violation?
That's interesting you say that. The picking up the new charges is a bond violation. The violation of the no contact would be a bond violation. Because she's at different stages. She's at different stages of the game right now. I mean, essentially. So those two would be bond violations, not so much a pretrial release, because the activity happened predates the jury trial. Is it? And that's the way I've kind of worked out the timeline on this.
March 31st is the alleged conduct.
Yeah, and April 11th is the conviction. So that would be a violation of pretrial, of the pretrial, since that stems from January 2nd conduct.
Was she also not under a sentence from a previous case?
She was sentenced on a previous case for October 30th conduct. There was probation. That was to a different victim. So that was to a different residence, I would assume.
Absolutely right.
But what was the date of that sentence, and would any of the probation conditions also be implicated by the new conduct?
So I do have, that's funny you should ask that, because I do have that file. And that's what I was trying to figure out, I have as a part of that file, which, for the record, but we're getting deep in the weeds on this one. That conduct was from October 30th, 2022. It was pled guilty to on November 23rd, 2022, as to a domestic with 769-4A status. It was referred to probation. The sentencing was held. Complaining victim gave a statement at the sentencing, and I had no contact with victim Chris Ostransky, no third-party contact. So I have no third-party contact. I'm just waiting to see at the order. I do not see any contact in regards to Rachel Ostrowski, and I'm uncertain that was the same address. That was a grant. So I just have, so in regards to that, not from what I see, was there any pretrial, any bond violation in regard to that very first order, which involved Christopher Ostrowski, not Rachel Ostrowski?
Yeah, he was living in a different, I don't think there's any factual dispute. He was living in Mason at the time that really all of this was going on.
I guess my point is, generally speaking, a probation order is typically don't violate any court orders or other state laws. And if she was sentenced on that, which was, I think the court said in February, and then the new case and new charge inherently is a violation of state law, that could also be a probation
Right.
violation.
I don't see that. I'm looking at the sentence, 7 days in jail. No contact with victim Christopher Ostrowski. No assaultive or threatening behavior, no use to possession of alcohol, submit to random PBTs, no bars or nightclubs, complete and attend women's domestic violence, obtain, maintain employment, no purchase of a firearm, defendant is restrained from harassing, stalking, or threatening, or engaging in that activity, 2, that would place Christopher Ostrowski in reasonable fear. So that was my concern also, and from that original. So I don't think that, so I think in order to do this correctly, or not correctly, just a belt and suspenders approach, is to make Ostrowski aware of the nature of these conditions, because we have so many out, this anticipated bond violation. It's not required by the statute, but I think due process would indicate that she should know what's coming at her and then we'll set it for hearing.
I agree in some substance. I may have a few points to make, but it doesn't matter at this stage.
Right, and I'm free to, that was just my thinking on this, is that we are at, I mean, I had to look at the files to make sure, because we're at different stages of the proceeding.
Sure.
And so I just wanted to make sure on my timeline that we do it with this approach. The sensing issue, I know the victims are here, essentially the sentencing issue on this case, I did not have time to look at any review of the sentencing memorandum that was filed last night. And so I think it's important that the prosecutor also review it and answer any memorandum. I think that's fair. I think that the victims in the case, since it went to jury trial, there was a hung jury the first time. The second time there was a jury trial on it, that the victims get to look at the indication, at least as far as the sentencing memorandum, in order to review so that they're prepared for the statement.
If I may inquire.
Sure.
And I want to make sure the people are on the same page as the court. We also received something around the approximate timeline the court indicated, and it's entitled Brief and Hearing Memorandum for Preliminary Examination. Is that what the court's referring to?
I am. I've got hearing memorandum and sentencing memorandum in this matter, and it was filed yesterday afternoon at 4:07 is when we timestamp.
I don't know if I have a sentencing memorandum.
It's one and the same. And
I think it's one and the same.
And what happened, Your Honor, is the date got changed and the email was sent with the PSIR to Mr. Moss. He didn't see the email until yesterday.
All right.
And so we were also working on getting the PPO transcript excerpt that we submitted. I'm just asking everybody, including Mr. Stevens and his colleague, to review it and keep an open mind about it. I've spent a lot of time researching these issues, and what's important is what her state of mind was when she.
Right, and I understand that. I would just like everybody to have time to look at it. I think it's important that Mr. Stevens and Mr. Brodowitz have time to look at it. I think the victims, since it is going to be referred to at sentencing, I think it's only fair that the victims have a chance to look at it so they can re-prepare or prepare their statement in regards to that this has been contested, as I think the record indicates on that sentencing. So my plan for today is to reset the probation violation and the sentencing on the same date. And then we'll treat the other matters separately. And then the plan today is also, so for Mr. Nichols, for your client's purpose, is to at least arraign her or do an arraignment so she knows exactly what the probation violations are about. Okay. I think that's fair, since there's been some confusion concerning the cases. Mr. Brodowitz or Mr. Stevens, any question concerning that?
No, Your Honor. No.
Mr. Stevens, all right. So Mr. Nichols, I'm just going to treat this as an arraignment. This is a bond violation arraignment I don't necessarily have to do this, but I think I should do this, so we're aware, okay? It says may under the court rule, that the allegation is that you had contact with Rachel Ostrowski. You came within 1,500 feet of where the victim lives, in regards to, that's in relation to the bond violation. And then we can find out what that means, all right? But that is the allegation. It's a no contact order. And that by doing that, you were charged and committed a new crime on March 21st, and therefore you were in violation of your bond, all right? Do you understand that's the nature of the allegations, ma'am? Okay, they're just allegations right now. Mr. Nichols, did I misquote that in any way, or?
I think so.
Okay, all right. I want to make that so you're certain as to why we're here and what occurred here. It's always bothered me a little bit, quite frankly, that we're going to have a bond hearing and the court rule doesn't require them to tell you what the bond hearing's on. And in this, the bond hearing's on an allegation that has not been proven yet. In essence, do you understand that? And I know it's different standards of evidence. I know that a bond violation is a preponderance of evidence and a allegation is a probable cause. But I just think this is a better way of making sure that you're put on notice of what you have to defend in regards to this. So we'll set the bond violation and the sentence, reset those for a date so everybody gets to look at the paperwork and familiar with it, and then we'll go from there. Any comment, Mr. Broadwitz or Mr. Stevens?
Nothing, Your Honor.
Mr. Nichols?
No.
All right, let's reset the bond violation. I'm not going to go into whether you have a right to a hearing in this, you know that. You have a right to counsel, you know that. You have Mr. Nichols here, who's here to zealously represent you during the matter. So we're going to reset it for bond violation hearing.
You want to just use the pre-trial date?
And well, we also have a sentencing date on that, and I will leave that up to counsel. If you want to set it all for the same date, we can do that. If you want to set the bond violation and the sentencing for separate dates, we can do that also. I'm going to leave it up to your discretion.
We do a separate date.
Right.
Just because I want to make sure I can be here.
Right, and I kind of want to keep it set differently from the new charges,
Yeah.
Although the bond violation certainly has a link to the new charges. So let's set a different date on that, on the bond violation and sentencing. Like the only thing that I would is that the probation department has to be available. So it doesn't have to necessarily be on that same sentencing date. Yeah, as long as they're available and works with everybody's schedule.
Do it on June 8th.
So June 8th at 2:30, does that work or not, Mr. Stevens?
For not, I have something in JMO
Okay,
at 2.
June 9th at 1:30.
June 9th at 1:30?
Yes.
Mr. Nichols, does that work, June 9th at 1:30?
This is one time that I'm going to agree with Mr. Stevens.
All
To
right,
do it on a Friday afternoon, but I'll make it work.
all right. I certainly understand that settlement, but June 9th at 1:30.
That's for the bond and sentence.
It is for the bond violation hearing, so we'll notify probation to be here and the sentencing based and the sentencing.
It's the bond violations of this probation.
Yes, probation will have to be here at 1:30. I think probation would have to be here so that in case there's an actual hearing, they have to testify.
I'm not actually, that's fine. So just
All right.
for BB.
So any record any question on docket 230011, Mr. Stevens?
No, Your Honor.
Mr. Brodowitz?
Nothing.
Mr. Nichols?
Just want to let everybody know, I dropped a reference to this in the pleadings that we sent, but we've researched MRPC 3.7, which is lawyer as witness, because of the role of Mr. Moss potentially in all of this. So I think we're comfortable that we don't need to withdraw, especially because it will work a hardship on this person.
Right.
On Ms. Ostrowski. So
Right.
I
And
think
if I'd had the chance to read that, I would have known that, but I didn't, so I couldn't.
And Mr., I don't necessarily want to say respond to it, but maybe add a finer point and offer whatever advice I have to Mr. Nichols. He sent that yesterday, the rule, and I reviewed it. I guess in the future, then it might be advisable to not introduce Mr. Moss as co-counsel if he's then going to be a witness. If it's just going to be Mr. Nichols handling the matter, he might just need to state his appearance alone.
Yeah, I don't disagree with that, but I'll leave that in Mr. Nichols, because that it's Mr. Nichols, kind of bailiwick.
Yeah, it's subsection B, a lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by
conflict rules.
Other sites.
Right.
So I understand what he's saying.
Yeah, and of course, we'd put any of that on the record, just so there's no ambiguity there.
Yes.
All right. So I will see everybody on this file. This is dual, because there's probably a pretrial order of no contact with the victim in regards to this actual file, 230011. And then I wanted to put the bond violation on the record because it's a violation of a previous case bond, as I see it. So, all right. Anything else? That's all for the record before we go.
Don't give any more chances.
No more chances. All right. Thank you for your appearance today.
Thanks, Mel.
Thank you, Ben.
What's that? Let's talk about this when we can talk about this.
Oh,
Yeah, because I think that's part of the problem is there's too many chefs. There's too many,
I just wanted to
there's
make
too
sure.
many chefs in this restaurant.
Have a good weekend.
You too. Here's that. Just stick that with that. Put it in the rubber band. They're all our files now.
Yeah, I'm trying to match up the probation sentencing to the rate.
Let me see him and we can all talk about that because we should all be on the same page on that.
I just don't schedule the morning.
Okay.
That, I just want to make sure that the J.
I'm not sure. I'm not sure what to call, but we're gonna
I did a
figure out.
bond violation and a sentencing date and a pretrial date on a different day.
You're right.
I just didn't do anything with the actual probation, but I think you want me to, but we'll talk later.
Yeah, and I'm not sure that's a violation of probation.
We're trying to figure out which one you said, or there's no notices for that, so. I don't think
For
it will
this?
be nice. Yeah, well, that's.
I didn't do a sentencing
That's the
notice?
after we're in, that's the last thing. This one.
I was like, the bond violation, in JIS, doesn't, for this one, okay, thank you. Yeah, this is the one I'm not sure what to start.
So we have Mr. Werwin and Mr. Johnson are still. And we know Mr. Johnson's zone. pretty much.
That's something has changed. in the last-
Your Honor, you're already on Johnson?
So we're ready to go on Johnson? All right. And then we'll leave Werewin for after that.
I think so. I think
All
that's
right.
the plan right now, Your Honor.
All right, so if we're ready to start, Mr. Milks, you're on both, so
Yes.
I'll let you make the call.
Going over there.
Okay, he's here? Okay.
All right, so we're on the record in docket 22-02458. That's people of the state of Michigan versus Cameron Johnson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Johnson, who is present and standing to my right at this time and obviously escorted by MDOC.
All right, and sir, you are Cameron Johnson?
Yes.
All right, this is the time set for preliminary examination. It's the court's understanding that this is going to be a held preliminary examination. Is that correct, Ms. Smith?
That is correct, Your Honor.
All right, Ms. Smith or Ms. Milks, are there any preliminary matters to be brought to the court's attention?
Your Honor, the people, and I would assume this will be a joint request, would request sequestration of witnesses. And also due to safety concerns, we're asking that the live stream be paused for this examination.
Mr. Milks.
There'd be no objection to that, Your Honor.